and others following our proceedings. This is the 2963rd meeting of the Human Rights Committee. We're continuing our dialogue with Macao SAR, and we were at the stage where colleagues had done some follow-up questions and the delegation was responding to the first cluster of the list of issues, that's 1 to 13. And so I think there may be some responses still to come, and then we'll go to the next round of asking questions on issues 14 to 25. So welcome back, Madam, and the floor is yours for the further responses. You have the floor.
Thank you, Mr. Chairman. Mr. Chairman, distinguished members, good morning. Today we would like to go over some of the issues which were raised by the distinguished members yesterday. And also we have some figures and data in paper that we would like also to distribute to the distinguished members. About the different issues that were raised yesterday, I will invite also my colleagues to respond to different issues. But I will start by answering the question of Mr. Shani about the number of judges in the court of first instance and whether this number is adequate and is enough to handle the cases in the court of first instance. So the number of judges in the court of instance is 28, as mentioned by the distinguished guest yesterday. And I would like to emphasize that from these 28 judges in the first court, 14 were trained by the Legal and Judicial Center of the Macao SAR since the handover. And 5 judges, they are recruited from Portugal. And 9 judges, they were trained before the handover in Macau, which is under the Portuguese administration. Up to 2012, so over the past 13 years, our Judicial Training Center has upheld 3 courses, and we successfully trained 25 magistrates. So these magistrates, 14 were appointed to the courts, the first instance court, and 11 of them were appointed to the Public Prosecution Office as the public prosecutors. There is still an ongoing, the 4th course of training of magistrates, which will complete by July of this year. And there are 12 intern, that is magistrates to be, and hopefully they will be qualified and to complete the course, and so they will be appointed both to the courts or to the public prosecution office. The number of the magistrates in the public prosecution office is 34, of which 4 of them were recruited from Portugal, and the other were trained by the local before or during the Macao SAR. I would like also to emphasize that as of December 2012, the total number of magistrates, that is both in the courts and both in the public prosecution office, is 74. And in the courts, in the 3 instances court, we have 40, which is 28 in the first course, the first instance, 9 in the second instance, and 3 in the court of final appeal. The total of 40, they are 8 from Portugal. And in the public prosecution office, as I have mentioned, so there are 34. About the cases in the first instance, first instance court, as of in the year of 2012, there were 16,189 cases in the first instance, making a calculation that is about 578 cases per judge in the first instance. For sure, we are gradually training more local magistrates, and whenever it is needed, we also can recruit qualified judges from Portugal, and it's happening in Macau. So after the fourth course by July this year, we will open another new course to train more magistrates for Macau. So I just want to emphasize that this is one of the important policy plan of the government of Macau to train, for sure, gradually enough numbers of local magistrates, and whenever it is not enough, we will recruit also from Portugal, and in order to handle the cases of the courts. Thank you. Thank you, Mr. Chairman. So I would like to invite my colleagues now to go through another issues. Thank you.
Honorable Chairman and members of the committee, yesterday there were members asking questions concerning juvenile crimes as to the measures that were taken for them. According to our new laws, there have been added new measures of a great variety for police, for social order, counseling order. There is juvenile residence for counseling, which is the most severe and last adopted measures. So if you want to know more about the relevant data, you may take a look at the 7 tables given to you, in which there's a detailed description the data between 2008 to 2012. For instance, in 2008, these 7 measures, when you put them together, there's a total of 422 of them that have been subject to these measures, but only 34 were subject to the last measure, only accounting for 8% of the total. In 2009, the total number was 287 for all the 7 measures that have been applied to these people. And the juvenile counseling measure was applied to only 10%, 39 of them in total. In 2010, 165 total. The most severe measure applied to 40 of them. 8.4% of the total, in other words. In 2011, the total number was 143. 12 of them were subject to the severe penalty, 8.3% of the total. In 2012, 116. The severe measure was applied to 18 people, or 6.8% of the total. So look at this data, and you will find out that the most severe measure applied to only less than 10% of the people. So it is the measure that is used to the least extent possible. As regards this question, I noticed that members are also concerned with the following issue. In other words, even the law 2007 provides that one juvenile has to stay no longer than 1 month in a single room, but maximum penalty is 7 days has been applied. So members were asking whether we should not, or rather we should, revise our law. Well, I would like to thank the members for having raised this question, a question we'll pay attention to indeed. Other members also raised questions concerning Article 12 and 13 of the Convention with regard to reservations on them. Article 12 and 13. Civil and political rights, this covenant, does not prohibit any reservation, actually. According to Vienna Convention of Laws of 1969, if the convention doesn't prohibit reservation without violating the purposes and aims of the convention, is a condition based on which a party to the convention can submit a reservation. The central government of China in 1999, on this issue of continued application of the Convention on Macao, sent a note to the depositor of the Convention, at which time, according to the basic laws, relevant provisions of the basic law of Macao, in conjunction with the status of the law of Macao and the actual situation there, the government at the central level made 4 statements. In compliance, these 4 statements were in compliance with the rules of relevant international laws. Other members also raised questions concerning numbers in Edam. Concerning question 9, we had given answers to that. In Article number 6 of our code, legal code, penal code, it says that you can't have 2 judgments on the same case. So this principle of the convention in the local laws of Macau is also applicable. And another question from the members concerning the quality of translation at the Legislative Assembly and the courts. But the quality of translation is something where you always can seek room for improvement. I would like to let you know here that in assuring the quality of translation, the government actually has taken various measures to deal with that issue. For instance, in training our staff working for the government who are working as translators, we have very long-term training programs for them. In addition, we also work with the European Union so that we can send our translators to that agency to practice their skills on translation. Additionally, there are people working for the government on legal translation who are paid with extra income as an incentive to encourage them, to encourage more people actually to engage in translation on legal matters. Besides that, there are magistrates that are trained locally, and we require them to understand both languages, in other words, Chinese and Portuguese. Measures of the government aside, institutions of tertiary level in Macau also provide courses of master degree on translation. We have foundations which also provide funds to our students who will then go to study in Portuguese with subjects of translation or legal issues. So we're hoping with these measures of various kinds to guarantee the constant supply of number and of translators of high quality, high caliber. Thank you.
Good morning, Mr. Chairman and distinguished members of the committee. I'm going to address two issues raised by the distinguished member, Mr. Kalin, issue number 3 and 13. I will start with number 13 because it's quicker. It is regards the negotiations that are being held between the Macao SAR government and mainland China and Hong Kong SAR regarding a bilateral agreement on criminal matters. Yesterday, Mr. Kalin asked us what is the approach of the Macao SAR government to these negotiations and what is the standpoint. As we said yesterday, we are under negotiations. And what we can say at this moment, at the present stage, is that Macao SAR government will take into consideration as a guideline the law on legal cooperation on criminal matters that we have, Law 6-2006, as a guidance for those negotiations. Regarding issue number 3, the independence of the Ombudsman, and the fact that he's being nominated by the Chief Executive, I would like to point out that within our political structure, if we look at Chapter 4 of the Basic Law, our Chief Executive has a dual function. He's, in one hand, what we can say the head of the state, because according to Article 45, he represents the Macao SAR, and simultaneously he is the head of the government, as we can say the Prime Minister, if we look at Article 62 of the Basic Law. On the Basic Law, we have two sections. One regarding the function of the Chief Executive, basically as a head of state. And then on Section 2, we have the functions of the government by itself, where in Article 62 we say that the head of the government is the Chief Executive. And is within Section 1 that in Article 59, in this capacity as head of the state, that the Chief Executive appoints the Ombudsman, and not in his capacity as a Prime Minister, as a member of as a government member. So, apart from this, Law 10-2000 that established a legal framework of the Commission Against Corruption specially states that the Commission Against Corruption is a public and independent legal body. It is led by Commissioner Against Corruption. Article 17 of this law reiterates that the Commissioner is appointed by the Chief Executive and endorsed by the Central People's Government. This means that the Ombudsman is accountable to the head of the state. The Commission Against Corruption has two functions. He has a double structure within his framework. He acts also as a Commission Against Corruption, and simultaneously he has another area of work that is independent from the corruption, that is the Ombudsman. So we can say that also our Commission Against Corruption has a dual capacity. He has an area where he acts as a Commission Against Corruption, he fights corruption, and he has an area where he has also public servants and a structure, and this structure for the Ombudsman. And the function of the Ombudsman is to safeguard human rights. That is what is stated in Article 3 of Law 10-2000. His powers as an Ombudsman are of several nature. He can make inquiries by its own initiative, when it's asked by individuals or NGOs, or even by the government. He can issue recommendations to improve human rights issues in Macau, to make amendments, make recommendations to make amendments, or even to revoke actions. It can propose legislation, amendments on human rights issues to the Chief Executive and even to the Legislative Assembly. He can make on-site visits, and he has access to documentation regarding in this exercise of his powers. The Ombudsman can also make awareness campaigns and dissemination. So these are the highlights that we can provide regarding the powers of the Ombudsman and his functions regarding the safeguard of human rights. As regards concrete data, we will provide it on a later notice, okay? Thank you.
Distinguished Chairman and members of the committee, yesterday some members raised questions on Macao SAR, on NGOs. They said that the NGOs are dependent on funding from the government, and so they very much are reluctant to criticize the government. They say also question the independence of NGO members. I would like to reply as follows. The Macao SAR enjoys close cooperation with NGOs. It's a partnership, and it has a very long tradition, and a very good tradition indeed. A lot of services, including healthcare, education, and community social services, they have progressed immensely, and this is thanks to the efforts and indeed joint efforts by the government and NGOs. The SAR government actively supports the development of NGOs through financial measures, through technical assistance, and through also assistance of providing equipment to support their development. We can see many benefits resulting from such cooperation. For example, the public has increased their participation in all kinds of services, and at the same time, different kinds of services are provided in the general public and in a more in-depth manner, so that the general public can really benefit from them, and it has greatly promoted social progress. Although, from a financial point of view, there is some financial assistance provided to NGOs, but they do not interfere directly into their internal functioning of the NGOs. We do respect the independence of NGOs, and we will not in any case change our policy or our measures due to criticism made by NGOs. We think that in the society there are different voices and different opinions, and that is why that the SAR government is very much open to criticism. Criticism, from a certain extent, is an incentive for the government to improve our work. And indeed, many NGOs are, in many occasions, including in public settings or in consultative committees or other settings, they have made criticism or provided recommendations, suggestions to the government. We very much respect their opinions and their criticism, and we are very much open to listen to their views and to engage in exchanges and consultations with them. That is for the benefit of improving our governance and also for the steady progress of our society. In the future, we will, as always, be committed to improving and to strengthening cooperation with NGOs. Through the mutual respect approach, we will continue to foster such approach and such cooperation for social progress. Thank you. Distinguished Chairman and members of the committee, good morning to all. Now I would like to take up the question raised by Mr. Shani on women entrepreneurship, on the percentage of women entrepreneurs and how to foster women entrepreneurships. According to the SAR government's statistics, for the moment, we do not have the actual statistics on women entrepreneurship. But according to the 2001 survey on the population, among the active population active in the labor market, there are 1,446 people claimed to be an entrepreneur. Of which 10,513 men, accounting for 74% of the total figure, which is the total figure, which is 14,046. And 3,563 women, accounting for 25.3% of the total. As compared to the 2001 population survey, the male entrepreneur are accounting for 83%. And women 16.7%. We can see that women has been increasing in terms of entrepreneurship, and they account for more in terms of entrepreneurship. I would like also to reply as to there is a business association for women entrepreneurship which was set up in 2005. That business association is a non-profit association and composed by women entrepreneurs from many sectors. Their aim is to foster cooperation among members and to improve partnerships and to expand market and to explore more business opportunities. That business association has more than 40 board members and plays an important role in the business sector in the local community. Now I would like to reply and to tell you about the initiatives and incentives provided by the SAR government to nurture entrepreneurship. It shows in the following two aspects. First, from an economic point of view, there are three types of measures from the economic point of view to foster entrepreneurship. The first one is the subsidies. If somebody wants to create a business and would like some subsidies from a financial point of view, then they can apply for subsidies. Secondly, is to provide with zero interest loan to the entrepreneurs. Every business can benefit from a maximum of 600,000 patakas of loan to be repaid within a term of 8 years. The third type of measures is to provide guarantee for loans. If medium and small enterprises would like to get loans from the commercial banks and need guarantee, then the government can provide up to 350,000 patakas for guarantee. Apart from these measures, we have also set up a service center for the SMEs. For those who want to set up businesses, we provide counseling and consultation services in order to simplify their administrative procedure. All these assistance measures are not only provided to women entrepreneurs, but are provided to men and women alike. Those who want to set up a business can benefit from such measures. That is my reply to the query by Mr. Shani. Thank you.
Okay, thank you very much to all the members of the delegation for those responses. We're now going to, if any colleagues have follow-up to the follow-up, perhaps you could just incorporate them in any interventions you make after or as part of the process of asking questions under the second cluster. But I now would like to move on to the second cluster, which is issues 14 to 25 of the list of issues. We've already had the presentation of the summary of the state parties' responses yesterday, so now it's straight over to the colleagues to ask their questions in relation to issues 14 to 25. And the first person on my list is Mr. Flinterman. You have the floor, sir.
Thank you, Mr. Chairman. First of all, I would like to thank the delegation from Macao SAR for their extensive replies to our earlier questions yesterday. Yesterday, I was reading the International Herald Tribune, and there was a short piece in the Herald Tribune drawing my attention. In that piece, Macao was characterized as the global betting capital. And it reminded me that hundreds of thousands of people every year cross the borders of Macau, most of them in a legal manner, but some of them, a number of them, in an illegal manner. And that brings me to my first issue, that's issue number 14, in which our committee raised a number of pertinent questions about the policies and legislation of Macao SAR on the issue of trafficking in persons. I very much appreciate the very detailed responses that the delegation has given in its written replies in the paragraphs 87 to 100. In particular, I would like to highlight the adoption and entry into force of Law number 6 of 2008, the anti-trafficking law. And it seems to me that the legislative framework addressed to issues relating to trafficking in persons is in order. But of course, our committee, Madam Head of Delegation, is not only interested in the legislative framework in states parties, but also in the implementation of the laws in place. And it's from that perspective that I would like to raise a few further queries under issue number 14. First of all, that's a very general point. If possible, I would like to have some information on the implementation and practice of the laws and regulations aimed at combating the trafficking in persons. Secondly, more precise, I would like to ask the delegation whether it would be possible to provide statistics on the number of investigations and prosecutions since 2008, since the adoption of the anti-trafficking law, and whether it would be possible further to also give an indication of the remedies that have been awarded to the victims since 2008. I would also be very much interested to know whether there had been investigations into the complicity of public officials in trafficking in persons. Further, I would like to ask you to indicate, if possible, whether there are appropriate protective measures for victims of trafficking in persons. And I would be interested to know what alternatives there are if a victim faces hardship or retribution whenever she or he is returned to her or his country of origin. And finally, I would like to have, if possible, some updated information on the measures which have been taken to equip the judiciary to effectively address cases of trafficking in persons. And in that respect, I also would like to know whether the number of prosecutors that are working on trafficking in persons cases has been increased. My next issue, Mr. Chairman, Madam Head of Delegation, are the issues 22 to 24, which to some extent are overlapping issues. And some questions have already been raised relating to these issues, and I'm not going to repeat them. I found it interesting, Madam Head of Delegation, that in your replies to issue number 22, which relates to the rights of migrant workers, the delegation stated that, and I quote, "Significantly, no complaint about discrimination has been reported to the Labour Affairs Bureau so far," end of quote. And indeed, reading the report and reading the responses to the list of issues, I found that significant. And I was wondering why there have been no reports on discrimination to the Labour Affairs Bureau so far. Is it because, and that seems to be the viewpoint of the delegation, because there is no discrimination? Or is it because migrant workers are afraid or reluctant to complain about discrimination because of possible repercussions, because they may lose their jobs, or because they are not aware? And for that reason, I would like to raise a few more questions about the position and the status of migrant workers in Macao as they are. And first of all, we have information before us that indicates that many foreign migrant workers have no formal contracts with their employers. And because of that reason, they become vulnerable to abuse and intimidation. And I would like to have your comments on that point. And secondly, we have been informed by you, Madam Head of Delegation, that Macao SAR has adopted a law on employment of non-resident workers. And my question is that law truly non-discriminatory in character? And in that respect, I would like to know whether the state party intends, first of all, to abolish the levy on employers of non-resident workers. Secondly, to lift the prohibition of transfer to other job categories of foreign migrant workers. And C, whether the state party intends to provide exceptions to the 6 months re-entry ban on workers who terminate their contracts. And further, we have information before us that many migrant workers in general earn less than half the wages of local workers who are employed in the same job. That contracts concluded between labor recruitment agents and the employer that contracts are concluded between labor recruitment agents and the employer rather than directly between the employer and the migrant worker, and that often recruitment agencies demand excessive fees from them. And I would like to have, if possible, Madam Head of Delegation, your comments on those informations. Further, we have reports before us that migrant workers are not provided with adequate protection and that there is no effective legal recourse in the cases of unfair dismissal. And once again, I would very much appreciate your comments in that respect. And that brings me to question 23, and there I would like just to indicate that I'm very grateful for the answers given yesterday to a number of queries raised by my colleagues on the issue of the position of women and disabled persons. And I was very pleased to read in your responses that the government of Macao, SAR, has recently decided to increase the pensions and other subsidies in relation to elderly persons. And that brings me finally, Mr. Chairman, to issue number 24. And there I have a few questions. In your replies to the issue number 24, which relates to the position of workers, including part-time and migrant workers, I have a few questions. First of all, in paragraph 147 of your responses to the list of issues, you indicate that there is no statutory minimum wage in Macao SAR, but that at the same time there are ongoing tripartite discussions on this issue. And my question to you is, what is the present status of those discussions and whether there is any timeline for final decision-making on the issue of statutory minimum wages? And my final question relates to the position of part-time workers. We have been informed by you, Madam Head of Delegations, through the responses that there is no specific legislation in relation to part-time workers. But I would be interested to know whether any progress has been made in formulating a legal framework for part-time workers, including any provisions on safeguards against discrimination and abuse of part-time workers in Macao SAR. And those were my questions under the issues which were assigned to me, Mr. Chairman, and I'm looking forward to the comments of the delegation. Thank you very much.
And thank you, Mr. Flinterman. Et maintenant, je donne la parole.
I now give the floor to the next speaker on my list. Ms. Motok, you have the floor.
Merci beaucoup, Monsieur le
Thank you very much, Chairman. I'd like to come back to the issue of trafficking, mentioned by Mr. Flinterman, with the issue of sexual exploitation in the territory of Macao. The government of Macao SAR is aware of this problem. It's already been mentioned to them by the Committee on the Elimination of Discrimination Against Women and the Committee on the Rights of the Child. We're talking here about people on your territory who are victims of sexual exploitation, and some of these people are forced to work to pay their debts. In your written responses that you've provided to us, you indicate the articles in the Criminal Code which have been put in place to put an end to this sexual exploitation of women. You have also indicated the measures taken to ensure that anyone who may have recruited these women must ensure that these women are not being recruited to pay their debts. So you have indicated laws, but you haven't provided enough information on the way in which these laws are applied. Apart from in the question where you state that there are investigations being carried out into the women who are arriving in Macau. And so we'd like to know something more about the sentences for the people involved in these networks, in these sexual exploitation networks, with the end country being Macau, given the specific nature of Macau. So I'd like to know specifically whether you have investigated these networks, whether you have taken specific legal measures as regards persons involved in these activities. Another source of concern for us in the conclusions we adopted on Macau is linked to the situation of persons found in Macau who were resident before 1999. And you say that these residents, that there's been a declaration adopted, joint Sino-Portugal Portuguese joint declaration, and you say that these inhabitants benefit from the same rights as other citizens, but given the fact that China only allows one nationality, these people can only choose Chinese nationality. So I'd like to know what measures have been taken to ensure that the rights of these residents are respected, these rights who previously were Portuguese citizens, and how these measures and this joint declaration are put in place specifically following, as I said, the adoption of that declaration. Another usual question from our committee is to ask you how you have gone about drafting this report. Have you received information from NGOs? It's true that while we have received information from NGOs, there is an awful lot of information missing as regards what we would tend to receive from other countries. And we'd like to know whether NGOs have participated in drafting the report, and we'd like to know how you intend to collaborate more specifically with them, and how you have gone about consulting NGOs in Macau working on the different issues under our covenant. Thank you very much, Chairman.
Merci à vous, Madame.
Thank you very much, Ms. Murdoch.
I give the floor to the next speaker on my list, Mr. Kalin. You have the floor, sir.
Thank you, Chair. I'm addressing issues number 16, 20 and 21. Starting with issue number 16, this relates to freedom of opinion, and we were asking for information on the extent to which provisions of the law on safeguarding national security are in line with the covenant. We raised some concerns regarding very broad notions that are not sufficiently defined. Thanks for the information provided. Also, I appreciate that you referred to some of the definitions that, even if they are not part of the law on safeguarding national security, they stem from the penal code. I very well understood that. Nevertheless, I do have some concerns here and some follow-up questions. First, we are glad that the law has not been applied yet to prosecute and punish anyone, including those expressing their opinion. But for instance, just to better understand the law, let me ask the following question. Would it, for instance, be possible to use the law to punish participants of a non-violent demonstration or a non-violent strike on the basis that this behavior can be qualified as an attempt to restrict the functions of the government? Again, it's a very broad notion, and any kind of strike or demonstration with a formal message, of course, wants to influence the government if this is the message. And where does a restriction of the function of the government start? Where does it end? You referred to the definition of state secret. Information that has been classified as related to national defense, external relations, and other matters pertaining to the relationship between the central authority and the Macao SAR. Other matters pertaining to the relationship between the central authority and the Macao SAR. Again, this is extremely broad. Does it mean that absolutely no criticism of this relationship is allowed under the law? Again, what we fear is that these very broad terms really could be used to limit freedom of opinion. Furthermore, we received some information, and that's probably one of the reasons why I'm insisting on this issue of how to interpret these broad norms. We heard that the law is quite regularly, or at least repeatedly, was it used to refuse entry to journalists from Hong Kong. We are not talking here about entry of anyone who is violent. We're talking about journalists. And then to ask how these journalists can threaten national security under the law, under these broad terms. I really would like to have some information on that. If it's not true that the entry was refused on the basis of this law, then I would like to know what else the legal basis were for refusing entry. Also, looking at the penal code, the offence of false or demagogic information that may frighten or unsettle the residents. Of course, robust criticism can unsettle people. I'm very often unsettled if people express robustly opinions I totally disagree with. But is this a crime? If it's a crime, then really we have lots of limitations on freedom of opinion. So could you provide me with information on how this crime of spreading false information that may frighten or unsettle residents is interpreted by the Macao authorities and the Macao courts? So these were some questions relating to the law. What about the practice? We heard reports, several reports, allegations of actual intimidations to express one's opinions. For instance, it was referred to a kind of culture of self-censorship among the media, because disciplinary measures are quickly used against journalists who kind of do not follow the lines they are expected to follow. We're not talking here about grave violations, but it's about a kind of a climate. Again, this non-entry orders regarding Hong Kong journalists, it's sending out the message that free reporting is not really welcomed. We heard about a recent case, February of this year, of the arrest of the director of the Macao Concealers publication. He has apparently, reportedly, videotaped activists. He was arrested and released, fine, but the video material was confiscated, never returned. Again, no penal actions taken against him, but it looks like this is adding to an atmosphere where free reporting is not really encouraged. We heard from activists who had been participating in demonstrations who were again detained by police for up to 6 hours, then released without any further steps taken against them. It's good that no further steps were taken against them. But if these kind of short-term arrests happen quite often, and this what was alleged, then again it's sending out a message. Robust expression of opinions is not welcomed, but discouraged. The same applying to the reported practice of the police of regularly videotaping demonstrations, and not just when they turn into violent events, also when they are very peaceful, the police advising citizens who are observing such manifestations not to join in. So I would like to really hear from you how you comment on these reports and allegations, and what the authorities' kind of approaches to robust public criticism, whether it's encouraged, whether it's discouraged. Thank you very much. That's issue number 16. Now let's move on to 20, where we ask to provide updated information on the percentage of locally born residents holding senior positions within the public administration. Thank you for the statistics. I don't have any further follow-up on that. This was very transparent and clear. 21. Here we ask to specify whether the state party intends to amend the basic law to ensure that more citizens have the ability to participate in the election of the chief executive head of the Macao Special Administrative Region. Thank you very much for the information provided on the reforms, particularly the increase in the number of members of the election committee for the chief executive. In the past, there were 300. Now there will be 400 members of that committee. We, of course, are very much acknowledging that there are many forms of democracy, that many forms of democracy are compatible with the human rights requirement. But if you're looking at the covenant, of course, the core of democracy, or one of the cores of democracy, is the right of citizens to participate in periodic elections, as provided for by Article 25, paragraph B of the Covenant. We are fully aware of the reservation made, but what we would like to know, and that's why I'm coming back to the issue, is certainly in a long-term perspective, the exclusion of the ordinary citizen from important elections is a problem for the Macao SAR, which for very good reasons want to be democratic. So beyond this reform, 400 instead of 300 members of the election committee, are you accepting that more steps are needed to move towards democracy as defined by the Covenant? And what are the mid-term perspectives? What are you considering in terms of next steps beyond the one that was just taken? Thank you very much.
And thank you very much, Mr. Kalin. Et maintenant, je donne la...
I now give the floor to Mr. Benasher. You have the floor, sir.
Merci, Monsieur le...
Thank you very much, Chairman. I have two questions to ask of the distinguished delegation. The first pertains to the integration of children of migrants in the school system. That's issue number 18. And my second question relates to corporal punishment of children. In particular in school settings, but also elsewhere. The replies provided by the delegation in its replies to the questions raised by the committee cover the features which characterize the report in itself. In other words, these are comprehensive replies. However, my first question, which is leaves me quite perplexed, relates to the responses in paragraph 116 and 117 of the list of replies. And these are replies to issue 8. In paragraph 116, you tell us that the public authorities and the government provide cash benefits to ensure to the residents, and I'll read out the text. I'll read it in English.
Immigrants, donc y compris les
including migrants who are in a regular situation. So the government of Macau is providing cash benefits to ensure residents, including immigrants in a regular situation, their right to education. So there is financial assistance which is provided by the state to enable residents to attend school as well as regular immigrants. And now I'm looking at paragraph 117. You tell us, with respect to the visitors who are permitted to stay in Macau for over 90 days, are not entitled to any type of assistance, aid or benefit. And this is at the end of paragraph 117. It seems to me that there is a paradox here. I'd like to have further explanation on the gap between the two paragraphs. I think there's a discrepancy here. There's a discrepancy, there's a lack of harmonization between the two issues in paragraphs 116 and 117. Perhaps I've misunderstood things, that is quite possible, but I would indeed like to have additional explanation on this paradox. I'd like now to turn to issue 19, corporal punishment. First of all, I'd like to commend the delegation for giving us the necessary information. The information is satisfactory. You tell us, first of all, that corporal punishment is considered by the Macau Criminal Code as an infringement against, or an offence against physical integrity. So it's punished in Articles 137, 138, 139 and 146. You also say that for pupils at school, you have regulations in place, particularly 46/SAAEJ/97, which prohibits any type of infringement against mental or physical integrity or personal dignity against students. So this really is protective in nature. And finally, you have another type of regulation or type of protection against corporal punishment, which comes under the Education and Youth Affairs Bureau. As I say, this is the Education and Youth Affairs Bureau. And you tell us that this service has disseminated a handbook with very strict rules and regulations. You have very strict guidelines on corporal punishment. But it doesn't only cover corporal punishment. The handbook also encompasses intimidation against students, or any type of pressure, or infringements on their dignity, their health. So we're not only dealing with corporal punishment here, really the handbook encompasses much more than that. And personally, I think that this is extremely positive. That is to say, to circulate within schools a handbook of rules and regulations on the prohibition not only of corporal punishment, but also pressure, intimidation against students, which could be an infringement upon their physical, mental health, physical integrity, personal integrity. I think this is very positive indeed. There is a question I'd like to ask, however. This is as follows. Do you have any broken down, disaggregated data on cases of corporal punishment or pressure exerted on students? The response that you gave in legal terms is a good one. Nonetheless, I feel that we don't have a quantified description in this particular field. They are the two questions I wanted to ask of you in terms of issues 18 and 19. Thank you, sir.
Merci à vous, Monsieur Benachou.
Thank you very much, Mr. Benachou.
The colleagues seeking to ask questions, some hands going up. First, Mr. Vatsilashvili, you have the floor, sir.
Thank you very much. I also have a question in relation with the issues of freedom of expression. My first question would be in the response, in the report, submitted to the committee, the report mentions that the press is provided with some financial incentives in order to increase their competitiveness on the market. I would appreciate the information if authorities use any other form of financial support to the press apart from those one, which is, as the report mentioned, it is used solely for the purpose of the developing their technical or technological base. So if there are any other financial support used for the press, and in what form it is made and how the funding is allocated. The report also mentions that the press agents may be held criminally liable, as well as they may be requested to compensate the damage. So my question here resonates with that of Mr. Kellen. Could you please clarify the notion of the abuse of the freedom of press, as it is mentioned in the report? And I would appreciate a clarification with regard to the whether, for instance, this abuse, whether the defamation issues are also covered by the criminal liability, and the person can be held liable on a criminal, according to the criminal law, for the defamation issues, in cases of defamation. And with regard to the compensation of damage as well, I have a question. In case of the report mentions that the press agents could be requested to pay the damage. So the press may journalists be also requested to be paid damage, or it's the law clearly stipulates that only the outlets or the companies which actually own the newspapers, only they may be liable or may be requested to cover the damages in case of court ruling. There is also a provision in the report, the paragraph, I think it is 454, which says that it is criminal liability. I mean, it will be criminal offense if somebody publicly offends the national symbols, including flag and so on and so forth. And then there is a list of possible acts of such which can be considered as a criminally punishable, including painting, damaging, and so on. So my feeling here is that this, at least the paragraph which is included in the report, I'm not familiar with the law itself, unfortunately, is a bit vague and might be even overbroad, and may cover many acts which might not necessarily intend to express a disrespect with regard to the national symbols, although the whole notion of punishing the disrespect of the national symbols may also raise issues, but I'm particularly interested in that aspect. And my final question would be with regard to the political parties, the way they are registered and operate. As far as I know, there is no special law, and the parties are either registered as non-governmental organizations, right? Or the limited liability companies, private companies. Is there any problems related to that? Are you aware of any concerns expressed by the different political groups that this type of registration makes their work a bit hard, especially in case if they have to choose the limited liability, the form of the limited liability company, which probably may fall under the different type of laws and regulations, including the taxation policies and so on and so forth. Thank you very much.
Thank you, Mr. Vatslashvili. I now give the floor to Mr. Shani. You have the floor, sir.
Thank you, Mr. Chairman. I would like to ask with respect to issue number 21, following up on Mr. Kalin's point. And the question is whether the Macao SAR accepts as a long-term goal the introduction of a system of election which complies with Article 25 and with the principle of universal and equal suffrage. Is the government of Macao SAR committed, or is it ready to undertake any commitment or to elaborate any timeline for the gradual introduction of such an election system? Does the delegation acknowledge the tension between the existing reliance on functional constituencies and nominated members in the assembly with the principles set out in Article 25, and specifically, can you explain to the committee to what extent has the introduction of the 2+2+100 system, to what extent does it reflect a step forward in the implementation or on the road towards the introduction of elections based on universal and equal suffrage, particularly in light of the significant representation of business interest in the additional 100 members that were added to the election committee. Thank you.
Thank you, Mr. Shani. Mr. Bouzid, you have the floor, sir.
شكرا سيد الرئيس. في البداية
Thank you very much, sir. First and foremost, as this is the first time I am taking the floor, I would like to extend a very warm welcome to the delegation of Macao. And of course, I would like to thank the delegation of Macao for the quality of their report, which shows that they are extremely competent and extremely professional. Sir, I would like to ask an explanation of the delegation as regards paragraph 79. It is stated that Article 4 of Law 6, 2008 has amended the criminal procedures, and the aim of this is to protect the victims of trafficking in human beings. I would like to know what exactly has been decided, what is stated in paragraphs 78 and 79 of Law 6/2008. Chairman, may I also ask an additional question? On the first section of the issues, if the legal counsel which has been mentioned, I would like to know if there's a law adopted which runs counter to Article 40, what would happen? This would mean, well, I'd like to know what procedures are open to citizens so that they can request the cancellation, the annulation of such a law. In accordance with Article 37, citizens can request a cancellation of administrative decisions. Now, what's the situation when a law runs counter to the Convention? Can a citizen submit a complaint directly to the courts? Can a judge himself, of his own volition, submit a complaint? And how can the problem be settled with respect to operational issues? Have there been problems in the past? Have there been complaints lodged? Have citizens lodged complaints against laws which were adopted by the Parliament? Have citizens stated that there is an infringement of Article 40 or a breach of Article 40? Thank you, sir.
Thank you, Mr. Bouzid. I see no one else seeking the floor. I will myself, if I may, just ask two follow-up questions related to previous questions and answers. Regarding NGOs in the State Party, there's obviously a vibrant civil society, but I'd be interested to know what kind of human rights organizations there are. In paragraph 11 of the written responses, there's reference to organizations pursuing labor rights, but that, which of course is human rights, but basically people working to defend their own rights and interests. And we'd be interested in human rights organizations that working to defend the human rights of others. Are there such organizations in Macao SAR? And finally, a very brief follow-up on the issue relating on issue 21 and the consultation that led to the increase of electors from 300 to 400. What was the nature of that consultation? Was there broad public discussion? Was there an opinion poll, a public opinion poll, or anything of the sort? And that is the end of our questions, and so with that we give you another break, Madam Chair of the delegation, Madam Head of the delegation, to get together with your colleagues and arrange an appropriate distribution of responses. So let's be realistic, a 15-minute break, and we'll start again, I hope, at 25 to 12, bearing in mind that we can't stray over beyond lunchtime. Thank you, Madam Chairperson. Thank you, colleagues. The meeting is suspended.
Thank you.